Well, care providers are seeking legal advice over whether they can force staff to have a coronavirus jab. A poll has revealed that quite a lot of people don't want one. It might mean that you don't get to work if you don't have a jab. I'm joined now by Julian Cox, who's partner of BLM Law. Also, it's head of employment law. Good evening, Julian.
Good evening, Nick. How are you?
Good, thanks. So, what are your thoughts on this? Can people be fired for refusing a jab?
Well, it's a particularly thorny legal issue. Now, as a starting point, we need to understand that the existing framework of employment law didn't really specifically take into account the possibility of a pandemic, the challenging times that we live in. So we need to orientate ourselves. And as a good starting point is to look at the existing regime of health and safety at work legislation, which has been in place since the 1970s. I know, Nick, before either of our time. Now, under the Health and Safety at Work Act 1974, employers do have a duty to ensure a safe working environment and take reasonable steps to reduce workplace risks. Now, to meet those duties, it may be the case in relation to certain sectors, in particular the care home sector, which I know we're specifically concerned with, which is at the vanguard of this pandemic, that it's reasonable for care homes to seek employees to be vaccinated. Now, all employers are certainly going to have to consider vaccination also as part of a COVID-19 secure risk assessment under their new health and safety obligations. Employees also have a duty under the existing Health and Safety at Work Act legislation to cooperate with their employer so that the employer can comply with their duties to reduce workplace risks. So we move on from there to ask, as a matter of pure employment law, can employers require employees to be vaccinated from an employment law perspective? And the answer to that is it depends. Now, that may seem like a trite answer, a typical lawyer's answer, but it very much does depend on the circumstances. So requiring an employee to be vaccinated on a mandatory basis does raise a number of serious employment issues and the risk of exposure to various types of tribunal claims that need to be thought through carefully prior to implementation so as to avoid unanticipated liabilities for employers. And the key question is, from the employer, and the employer needs to preoccupy themselves with, is it a reasonable instruction? And that will very much depend on the circumstances. Now, I feel for employers in the social care sector, it would be relatively straightforward for them to argue before an employment tribunal, if required, that it does represent a reasonable instruction for employees to take the vaccine before, because a refusal could put vulnerable people, i.e. residents in their care home, at risk. But at the same time, there are a number of other important legal considerations that care homes need to consider when dealing with an employee that's refusing. Now, for employers in other sectors, there may not be so strong a justification for instructing staff to take the vaccine. As an example, an accountancy firm, professional services, a professional service industry has found it easier to deal with working effectively from home. So the rationale changes from sector to sector, really. So, and in terms of the action that can be taken.
What about people that would that don't work in the care home industry, but work in the sort of job that would take them into other people's homes? Now, you don't know whether somebody's vulnerable in a home when you arrive as a plumber, for instance. And
Yes.
Pimlico Plumbers chairman Charlie Mullins said that he plans to rewrite all of his workers' contracts to require them to be vaccinated.
Yeah.
How does that sound?
Well, again, I can see the justification for requiring people that are going into people's homes to require them to take the vaccine. Now, you need to remember that in the case of Pimlico Plumbers, their workers, you quite rightly use the word worker, they fall into a slightly different category in terms of employment status to employees. Now, for employees, you've got unfair dismissal rights to take into account. So in terms of changing terms and conditions or taking action against them if they refuse the vaccine, then you've got that to contend with, and you need to follow fair procedures. But in the case of workers also, in terms of requiring them to get a vaccine, there are other considerations at play. Now, there was a case a few years ago, 2 years ago, I think it was, in 2018, involving Pimlico plumbers, coincidentally, that got all the way to the Supreme Court. And in the case of one of their workers, they were judged to be a worker for the purposes of employment law. Now, the significance of that is that workers have discrimination rights also. Now, I don't know, and I wouldn't dare to speculate as to what the current status of those engaged by those at Pimlico Plumbers currently engaged, what their employment status is now, particularly in the light of that case. But if there is a plumbing firm out there that engages people as workers, it's not simply a case that you can impose a requirement to take that they are required to take a vaccination, because there may be good reasons under discrimination law, for example, as to why they are unable.
What sort of reasons are you thinking of?
3 in particular. So what we need to be thinking about is the Equality Act 2010. So first example, a protected characteristic under the Equality Act, disability. There may be some individuals who are advised by their doctor or consultant, if they're under consultant, not to have the vaccine due to a medical condition. Now, a worker or an employee with a particular form of disability may be unable, therefore, to take the vaccine. If they simply say no, then the employer would need to properly understand why and factor those reasonings into any decision-making process, particularly mindful of the employer's duty also under the Equality Act 2010 to make reasonable adjustments for an employee whose medical condition affords them protection under the Act. There's your first example. Second example, pregnant worker or employee. The vaccine is not recommended for those who are pregnant, breastfeeding, or planning to get pregnant, as I understand it. I'm not a doctor, but that's my understanding of what's being said about the vaccine. And then thirdly, and this is really interesting, religion or belief. And there's an interesting debate going on amongst employment lawyers at the moment as to whether the anti-vax movement attracts protection under the Equality Act 2010 based on their beliefs. Also, what about vegans that may object to animal-based products that are sometimes used in vaccines? Again, I don't know the precise makeup of the different types of vaccines that we've got. Fortunately, we've now got coming into play now, but potentially. Now, belief in the context of the Equality Act means, and I'm quoting here directly, it's the only bit of employment law you can hear from me directly this evening, but it's important, means a philosophical belief that is genuinely held, that is cogent, serious, and applies to an important aspect of human life or behaviour. The belief must be worthy of respect in a democratic society and not affect other people's fundamental rights. Now, whether the belief is protected is likely to depend on the individual circumstances, but theoretically at least, it's possible that these types of belief, contravention of belief, could be discrimination. As I say, though, every situation will need to be considered on a case-by-case basis. Now, that's discrimination. Yes. Now, we haven't even, looking at employees, they've got additional protections as well. And it's really important that employers, when they're dealing with employees, follow fair procedures. Why? Because there could be a risk of an unfair dismissal claim. And they may have a claim regardless of length of service, because where they've raised issues about health and safety, for example, there's no 2-year qualifying requirement. So if I'm talking to, if there are any employers listening tonight, then I would say that, you know, going through, if you've got a refusal from an employee, and that includes care home sector employers, then you need to be seen to be properly communicating with your employees. You need to properly understand the reason as to why your employee is refusing, and you need to give it proper consideration and look at alternatives before just like a bull in a china shop going down a dismissal route.
But what about somebody who, I mean, these people are not small in number, who think that the vaccine is a plot by Bill Gates to introduce a microchip into their brains with which he can control them. I mean, that is a sincerely held belief. Prove otherwise.
Well, this is it, and it's a good question, and it touches on what I've been saying about whether a tribunal would consider that to be a belief. Now, we need to introduce an element of common sense here as well. And my 23 years of experience of being a senior employment lawyer and working in the tribunal, tells me that employment judges have a modicum of common sense as well. And they do look at this idea of belief, and they do take a more sanguine point of view. So I can imagine that a fairly robust employment judge, and there are many, would look at this and would just say, no, Dice, we don't consider that affords you protection under the Act. I mean, let's not forget, many years ago, people were claiming to be Jedis,
Well, maybe they were.
Protection under the
Maybe they were.
Didn't get them very far.
Do you think that this might sort of be a wedge to open the door to employers demanding other sorts of medical procedures, like birth control, for instance? Because if somebody is in line for a jab and they say, well, I've just found out that I'm pregnant, so that gives me a pass.
Oh, gosh. Do you know what? I think it's an interesting question, but I think I can immediately see that other discrimination rights coming into place there, discrimination based on sex, maternity, pregnancy rights, that sort of thing. If I'm acting for the employer, I really wouldn't recommend they even consider going down that route. I think there's enough there's enough minds and it's a bit of enough of a minefield in terms of navigating COVID and compulsory vaccination at the moment without adding that into the mix. Definitely.
Okay, well, just finally, is it possible that getting a vaccine will make you a citizen rather than those that do not get a vaccine, who will become non-persons and they won't be able to fly and they won't be able to go to the cinema or restaurants and so on? Is that a possible future?
I can see it becoming more difficult for individuals if they don't subscribe to the vaccine, if they don't buy into vaccination. I can see that. But I can also see as well this business of holding information, employers holding information as well about vaccination and stuff like that, raising all sorts of other legal issues, not least data protection. So in terms of the availability of that information to employers, to airlines, that sort of thing, we haven't even touched on it this evening. We could go for hours, Nick, in terms of other legal considerations at work here, not least of all data protection considerations. So I would strongly suggest that if you're an employer and you're looking at vaccination, that you should be taking considered legal advice. Of course, I'm going to say that, but, the liabilities, it's not just employment law, but there's all sorts of other legal liabilities at work here, which you may, as an organisation and or employer, inadvertently fall foul of.
All right, thanks, Julian. That's Julian Cox, who is partner of BLM Law.